Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from WILDY, Simmonds and Hill. It's on mortgage receivership, law and practice, and it's been written by two people, Tozer and Cecily Crampin. Excuse me. It's about mortgage arrears. That's the subject matter. The subject matter you don't want to talk about is what our heading is, and that's basically, I put that in specifically. Elizabeth and I talked about this book. It's always a subject that causes a lot of trouble, and more so than even now with mortgage possession matters going way up again. Let's have a look at the book first of all. It's a hardback, purple edition. You probably can't see that too well, but there we go. There's the front, then there's the spine. There's nothing on the back. You can see the spine. It's a hardback. It's a very good book. I was very impressed with it. The actual index which is there is by paragraph numbering. It's always you've got to be a bit careful with these indexes because some of them are by page numbering. References are to paragraph numbers, and it's quite useful so you know how to get around the book quite quickly. The index is a detailed one, and I think I found it quite helpful when I was looking up certain things. There's the front page there, which I thought was very helpful. Now there's the blurb about the book, and that's the dedication. I like to show dedications because a lot of people are involved in these books, the production of these books, the writing and so on, and it's nice to know that they're dedicated to someone. The foreword is worth reading because that sets the scene very nicely for what this book is about, from Mr. Justice Morgan, Sir Paul Morgan. And then you've got the preface from the two authors, which is also worth reading. I borrowed a bit of Sir Paul Morgan's comments for the review. That's the contents section. You can see it runs through. It's quite a substantially detailed contents section. The total number of chapters of 14. It ends up with dealing with the litigation side. Then you've got an appendix at the back, dealing with various different areas. Then you've got table of cases, and there's some quite good ones that really are mentioned there. Some important ones. I'm sure many of you who are involved in this area, as I am, will know of some of the cases. Then you've got the statutes. Then after that you've got some statutory instruments. And then after that, we've got some European material. You do get European material in a lot of these publications today, and it's not going away with Brexit. Then there's non-statutory material as well. That is looking at practice guidelines and so forth. And then you've got VAT notices and so on. And then you've got the list of abbreviations. Not too many, but enough. It does help because, as with everything, especially in land law and this area of law, there are quite a lot of abbreviations. See the structure of the book. There is the paragraph numbering, and then you've got very detailed footnotes all the way through. And that runs through, you can see that's the middle of the book there. Same sort of thing. This is looking at equitable compensation. Again, paragraph numbering and the footnotes. So, what do we say about the book? Well, I was really impressed with this book. And I think that's very stern judges looking at it here. I was very impressed with this book for one reason, and that is that it's an area that I'm involved in. And it's not it's another area that needs a bit of reform, I think. But we're looking at that in the longer term. What we're talking about at the moment is that many people have words for those dealing with mortgage receivership, and the language is generally rather unattractive imagery because no one wants to talk about the law on arrears. It's a difficult area, and it does lead to huge amounts. It has in the past clogged up the county courts, no doubt about that, and it does cause a lot of difficulty. So step forward this excellent book from Tozer and Cecily Crampin. It's an important work on the law and practice of what is called mortgage receivership and the way we go about it. But do start, before you do anything else, by reading the preface from Paul Morgan, because I think that's very important. It sets the scene very well. The title, of course, which we've got, is concerned with mortgagees who often appoint receivers themselves if a borrower falls into arrears, because obviously they're trying to get their money back. Perhaps because of the prevalence of buy-to-let mortgages, receivership appears to be used more often in the residential context than formerly, which has led, of course, to some recent and very interesting case law decisions. These cases concern the way the courts test the effect of the receiver's agency, bearing in mind the structure that the receiver is being created to look at, the actual structure and the way he goes about it, or she goes about it. It's agency concerning residential landlord and tenant law, and it includes some important decisions. One is Hellman and John Lyon Free Grammar School Keepers and Governors from 2014. That's in the context of a claim to acquire a freehold of a house in an enfranchisement under the Leasehold Reform Act of 1967. Complex areas, and you can see it's basically the test that has been created. Then the authors also review the decision of MacDonald and MacDonald from 2014, which was also appealed on other issues, but we're looking specifically here at mortgage receivership, which decided that receivers could serve a Housing Act 1988 Section 1 notice on a tenant of the mortgagor. And the case, of course, I think will be of use to those instructed in Section 21 matters. You will find quite a lot of help at the back of the book, depending on what you're specifically looking for, because this is actually of more use probably than some of the other practice books that we have that we use regularly. And I'm not decrying any of the other publishers at all, but this is a very good book, this one. Now, what Tozer and Crampin have sought to do here is to answer crucial questions unanswered by the recent case law. As a main purpose of the title, what is the source and extent of the receiver's agency? In other words, how much power have they got? What can they and can't they do? Can receivers, for example, take possession against the mortgagor? And when can the receiver be in a better position as regards third parties than the borrower is? And it's a detailed and authoritative text as a result from two authors who've got a lot of experience in this area, and they're trying to cover all aspects of mortgage receivership, which will be, I think, of great benefit to many practitioners in this area of law. May also be relevant, of course, to unrepresented parties. What the authors do is they survey current case law well for those unfamiliar with it. Now, you've got the Legal Action Group. You've got a number of other areas where there is tremendous assistance for unrepresented people, and they are obviously a very large number of people now in the courts. But this book, I think, is particularly relevant depending on what you're caught by. I've only had a couple of cases involving this particular area, I have to say, but it's useful to know the existence of this book, because when I did the cases, I didn't know about the book at all. What the authors therefore offer is an analysis of the nature of the type of receivership in order to answer some of the questions on which there is no direct authority, which of course will therefore be of some use to counsel. And certainly that's what I found of use, because it will give me some ideas about how to approach the instructions I've got from either the client direct or the solicitor. So let me summarise by saying the work gives us as lawyers and advisors and unrepresented parties some practical advice about what receivers should do in situations, in some types of situations, and how litigation involving receivers should be conducted. And of course, like all WILDY, Simmonds and Hill books, this one remains essential reading for lawyers advising receivers or who are involved in litigation for or against receivers, and for receivers themselves. So thank you very much indeed for publishing it. I do think it's an important book, one that I'm very grateful to be able to review, because I think it makes our work a great deal easier, because you've actually got a lot of information here at your fingertips in this particular area. The book was published on the 8th of October 2018, and let me just have a quick look at it again so you can just check and see what it looks like. Oops, just pick that up again there. There we are. There's the front, there's the spine, and then got nothing on the back. Just opening it in the middle, I'm just opening it here. This is the power of attorney, receiver's relationship with the borrower. A very important point, because obviously the role of the receiver is of paramount importance, of course, but again, you can see the structure of the book. You've got the paragraph numbering and you've got the footnotes. You've got quite a lot of detail. There's a lot of factual information, but there's also, you can just see going over it, a lot of case law, because they actually they've done their homework. And then we go on to chapter 7, the receiver and the lender. So it's looking very much at trying to give you the complete picture on how mortgage receivership law and practice operates. I think they've succeeded, and I'd like to thank everybody involved at WILDY, SIMMONDS, Hill very much indeed for producing this work. As I said, it's a lot. It makes everything so much easier for us when we have works like this. So a big thank you to all concerned. Bye bye.